everyone, this is Gabby for Lawyer Talk Thursday, writing solo. Prepare to answer any of your questions you have with family, criminal, and I saw a couple of immigration ones there. Looking forward to our chat. Yesterday, Alex and I were talking about assault family violences and their effects on different type of cases. So let's first look at how it affects child support, mainly child visitation. So in an instance where the other party is convicted, either a final conviction or even a deferred, the other parent has the right, based off of that conviction, to go ahead and modify the support. As far as how they parent access, when they get to see the little one, and ultimately it does go into the purse strings, right? They can even request support based off of that. So it's important to talk to your attorney if you're faced with these issues, both family and criminal, to see how they impact. So now let's look on divorces. Divorces and assault family violence. We touched on it briefly last week, but when you're looking at it at this point, if you don't want to be on the hook for spousal support, it's important, once again, to not only talk to a lawyer, because at this point, if that allegation is raised, you could be stuck with it. It can be happening during the pendency of the divorce, or if it occurred 2 years before the divorce filing. Weapons. Guns are big in the Lone Star State. And how does that affect it? Well, you have two issues. You have the protective order, or you have assault family violence. So when we're looking at specific family violence cases, as far as what the final result is, you need to look at as far as what you're charged with. Is it a felony or a misdemeanor? Statutorily, if you're looking at a misdemeanor assault charge, family violence case, you're looking at 5 years from the date of release of community supervision or confinement as to when you can own or purchase a new gun. Now, if it's a felony, you'll be looking at 5 years from the release from confinement or community supervision, plus another 5 years. So think about it, talk to an attorney, and get to us to see how we can prevent that from affecting you. Let's discuss protective orders. We talked about a little bit about it last week, but let's go a little bit more in depth. A lot of questions that we've been getting lately are regarding orders and no police involvement, no criminal history. Well, they can still file for protective order even without any of those police reports. Let's start with an example. You're in the middle of getting a divorce, you're not getting along with your ex, and there's an allegation of domestic violence. Going up to the 5th floor with the county attorneys, if they find reason to, they can grant that order. They can even limit your ability to either own weapons, access your children, or return to your property. So it's important to always talk to an attorney about what are these orders means and how do they affect you. So what I'm saying is no cops were involved, no history was given other than this statement to the county attorneys. An order is issued. What happens now? Realistically, if a judge were to grant it, it can be extended for up to 2 years. How that may affect you is if you were found in violation of that order, you would be now looking at criminal charges, which means the DA's office would not be prosecuting you for this order that was filed in civil court. Hey guys, thanks so much for tuning in. If y'all have any questions, feel free to pop into our DM, send us a message, or call our office.